were appointed for a period of only 1 year. The contract was only 1 year, and it is mentioned in the para number 2 of facts. And it is stated that the contract will automatically be terminated on 1st June 2023. And the incident took place almost after 12 days after the expiration of the contract. Our third ground is that the ship on which the incident took place is not registered in Juris. It is registered in Babel, and the killing of the Ruzin Kazalbash took place in high seas. Besides that, our position council themselves negated their jurisdiction by mentioning the extradition laws, and Juristan and Nana are signatory states. So according to that, the accused shall exchange the signatory state shall exchange the accused. Juristan is duty bound to do so. The second issue is whether the killing of Dilruzain Kazalbash was a murder, considering the circumstances of this case or not. Considering the circumstances of the case, that the killing of Dilruzain Kazalbash does not amount to murder. The reasons are there is doctrine of necessity, which means to take certain actions that must be taken at a particular moment, where in situation, individuals may resort to cannibalism as a means of survival when no other resources of food are available. Among the 6 elements of necessity of defenses, the third element of would just be justified here is the causal nexus form. May I read it out? The action taken in the cases considered all appear to meet this prong is that the action of killing will usually have the direct result of saving a greater number of lives, for example, by cannibalizing the flesh of the victim or by ejecting people from an overloaded lifeboat. Remainder of the group will then be in a condition to survive. Yes, ma'am.
You have mentioned in your legal question number 3 in paragraph that when there is a conflict between general and special provisions, the later shall prevail. What do you mean by the general law and the special law?
Both Armagan, Randava, and Dilruzain Kazalbash are the nations of, which means that religion is mostly practiced by a lot of people in that nation and state, and there must be some kind of laws for their religion. So when there's a conflict between local laws of Juristan and local laws of there, the later shall prevail. They should be dealt with their own religious beliefs and their laws.
So you mean that the evil conduct will prevail in morality?
Not exactly, but I am saying that if there are like there is a doctrine of necessity, they did it on some kind of defense to preserve their lives, and there's also a ground that they have the excuse by religion that in certain circumstances they can cannibalize on human flesh to survive. So in that case, they have that defense and they can use that.
Survival at the cost of someone's life.
Dilruzain Kazalbash was in a really severe situation. He was about to die, but the killing of him saved the lives of other crew members. If he died without them killing it, all of them would have died. This is a defense, like they have the necessity.
The proximity of his death does not allow or exempt someone to kill, murder.
But it averted a greater harm. Instead of getting 4 crew members killed, only 1 died and the other 3 survived. They averted a greater harm.
Sir, when it comes to very first issue jurisdiction, as you have mentioned, moreover, it is a matter of international court of justice. क्या उन्होंने treaty में ये चीज mention किया था कि there will be a dispute.
I'm sorry, sir.
जिसे कि आपने mention किया हुआ है कि it is a matter of international court of justice. क्या दोनों parties इस चीज पर agree थे कि हम इस matter को अगर dispute arise हुआ तो हम उसको इस court में ले जाएंगे?
Sir, first of all, they were signatory states. Second of all, the incident took place in high seas, and the matters dealt by the water are by international court of justice and international tribunals. Since it was in high seas, it should be dealt in third place, not by the states.
So you offense high seas in economic context.
Yes, sir.
Would you assist the court regarding Article 73 of UN clause?
Do you have any relevant fact, as such, which mentions that their height is more?
Para number 5, it stated that they drifted apart from like 340 nautical miles.
When was the offense
Uh,
in which para it is mentioned?
the offense was committed after like 12 days when it between 11th and 13th July of 2023. No, to 27 May 2023. After he fell into a coma. The para number is
As far as I know about the facts on ground,
this
the
one.
offense was committed and it is mentioned in para number 10 of the facts. And when it was committed, it was within the extendable, within the local ambit of the Juris, which comes 250 nautical miles. So it is not high sea.
No,
High sea is international water, right?
the exclusive economic zone, it does gets that to that limit, but they do not discuss criminal jurisdiction. None of them clearly discusses criminal jurisdiction. They are only limited to economic purposes.
There is always jurisdiction regardless of if it is criminal or civil. It is a legal jurisdiction over the matters that concerns or damages the good order of the coastal state, right?
But the criminal jurisdiction is only limited to 12 nautical miles, not after that.
Earlier you mentioned that it was done in economical zone, and the economical zone is extendable to 200 and right?
But not with criminal jurisdiction.
What's the difference between EEZ and criminal jurisdiction?
So they are like discussing their limit is about like with the purposes of economic, like they are economical.
What if an economical crime happens in EEZ? What if a theft happens?
Can I have an illustration?
What if someone burns the material? What if there is a shipwreck because of someone's criminal activity? Then who's going to be it?
Like, is there a death happening?
What?
Is there a death happening?
In our case, a death happened, right?
Yes, sir.
And you are saying that this does not apply in this jurisdiction because it comes under 12 nautical miles. And the EEZ is 340 or 360, whatever it is, right? But apart from these things in the economical zone, there is a ship fire, the material gets stolen, there are the ship pirates, something like that. Whose criminal jurisdiction is this place under them?
The third place, International Court of Justice and International Tribunals.
How would International Court of Justice deal in this matter? It is coming in our EEZ, economical zone.
Then they will come in Pakistan Merchant Act.
Sorry?
Then that will be coming in Pakistan Merchant Shipping Act.
Pakistan Merchant Shipping Act. We are living in Juristan.
Merchant Shipping Act. I'm sorry,
Okay,
sir.
proceed.
Thank you.
Yes, Mr. Counsel.
Yes, sir.
For the sake of the argument, you mentioned that it is the 340 or 360 nautical miles, whatever the zone is. Do you have access to your extradition act that you have provided here?
No, sir, that's video.
On page number 5 in the chapter 4 miscellaneous, it says that where the offence in respect of which the surrender of a fugitive offender is south was committed on board any vessel on the high sea or any aircraft, the air outside Pakistan, or Juristan territorial waters, and such vessels or aircraft comes into any port of, or aerodrome of Juristan with the fugitive offender on the board. The federal government or the magistrate having jurisdiction in such port or aerodrome is also saying that if a particular offence has happened within the zone 340 nautical miles, then the Juristan Penal Code is going to be applied.
First of all, there's also that we mentioned that it took place in high sea. The high seas will be on the ring or under the flag that the ship comes under.
If in case for the sake of argument we say that it was a flagship, whose flag was there on the ship?
Nana. No, Babel. It was
Babel is
resistant.
a disputed territory having war,
The
right?
Juris, yeah, yes.
So, with Eurasia. So, how can you justify this that if in case we try that particular offender inside Babel, thus international humanitarian law does not apply on this fact that a particular territory having war and the particular domestic laws get sabotaged. So, why don't we try it here?
But we also mentioned that none of the states should be should held the case. The third place should be responsible to hold the case, and that's International Court of Justice and International Tribunal. Neither Juristan nor NANA should be trying this case. Does that satisfy you? So I can go. Thank you. Beside that, we also have that there is an absence of mens rea, and furthermore, it is to be noted that the crew members were in a state of extreme duress. They had adrift for days without food and water, and they were desperate to find a way to survive. On June 11th, a suggestion was made to draw lots. All the crew members, including Kazalbash, agreed and participated in the drawing of lots. The lots were drawn, and the losing Kazalbash was selected. All of these are stated in para number 8. And related to the drawing of lots, we have sortation. Sortation is a drawing of lots. Seamen have practiced this for centuries in situation of grave travail when they must draw. The slave was shot dead, cooked, and eaten. About 4 days later, the crew was rescued by a passing ship. Besides that, there is also an example on a convoy of 3 boats for St. Helena. The boats soon parted from one another, and some of the survivors ended up casting lots for sacrifice. And in the last line, it's also mentioned a legal procedure.
About that refusal in the subsequent
We have another example, the Spelonsian explorers. The person there for the killing of the losing Kazalbash. If any criminal liability was.
Okay, let's say for the sake of argument that the act was legal, it was justified, but it was done illegally. So it's a criminal conspiracy.
There's absence of mens rea. There is no malicious intention. There is no predetermination. There is no shared ability.
There is access to crime. So it is a conduct crime.
But available to them, and they had to resort to that.
Means benefit prevails over the human life, over the morality.
To avert a greater harm. Our cannibalism under the theory of necessity varies upon the matter of jurisdiction and specific circumstances involved. We would like to quote Justin Belvin. He gave a persuasive principle from Chapman Law Review 174, page number 174. He quote that it is worth remembering that in any situation in which the necessity of doctrine applies, someone's rights are going to be violated. And here, the rights of the losing Kazalbash happen to be violated to save the other crew members. And with all these issues, if it may please the court, I would like to call my co-counsel for the remaining issues. Thank you.
Good morning, Your Honors. I'm Fahim, and I will go with the fifth issue. I will go with the fifth issue of the moot problem. That is whether or not the principle of common intention applies to Arazwagil and others. Your Honors, it is clean and clear that there is no application of common intention in this case. I would like to quote the section 34 that deals with the common intention. Section 34 of the JPC says that acts done by several persons in furtherance of common intention, when a criminal act is done by several persons in furtherance of common intention of all, each such person is liable for that act in the same manner as if it were done by him alone. Your Honors, we submit here that the elements of common intentions are not justified in this case. The main element is the mens rea, and the element of mens rea is not justified in this case, and we defend that there is no application of the section 34 in this particular case.
Counsel, your time is up.
Yes, Mr. Counsel. Just answer this one thing. That when it comes to the common intention, that says the furtherance of common intention, right? And there is a particular thing known as a specific role in common intention.
Definitely.
That means that those two people, one was holding him by his foot, and the other person was commenting on the deliciousness of the meat.
Definitely.
Don't you think that this is the specific role they are playing in furtherance of that common intention? Now, how
Yeah.
can you say that there was no mens rea?
Your Honors, there was furtherance, and we admit that thing, but we are here defending the section 34, and we are here defending the charge of common intention. And they lacked mens rea. They didn't have even intention. They were coping with an extreme situation. May it please the court is if there are any further questions
Do
regarding
you
this.
not think that the negligence of or shortage of all those the food, shortage of food and other necessities, you can put it on the men, I guess, right? This is the company who facilitated this voyage, right? Do you not think that the negligence falls on them?
Pardon, Your Excellency, I couldn't get your
You
question.
said that you were caught, your client was caught in a dive,
Definitely,
in a very extreme situation.
definitely,
Yes?
yes.
So do you think that this negligence would fall on someone else who facilitated the voyage and could not come up with the adequate resources for this voyage?
Your Honors, we submit here that the Zizu company provided enough resources to with the lifeboats and other equipments. They could have used the lifeboats and other equipments to evacuate and save their lives. So
So
there.
you are indirectly admitting the fact that there was another alternative solution for this.
Your Honor, I was just clearing your question.
So yes, you have answered my question, but your answer imparts the meaning that there was also another alternative solution to save their lives.
Your Honors, this case is different. That if there was alternatives or not, this is on the prosecution. They may prove there was alternatives or not. But here we are discussing that they had to do it for the necessity, according to for the in the necessity of defense, and they had to do it to save their lives, and they did it with the consent of everyone, with the consent of Qazalbash. They drew lots, and Qazalbash was selected, and they went
Please
with it.
mention the paragraph where he consented.
Yes,
The
Your Honor.
actual and the last consent.
Yes, Your Honor. Your Honor, as my counsel submitted that according to the custom of sortation, if a person first admits and takes part in the drawing of lots, and then after then he is selected and he tries to withdraw himself, the custom suggests that because it has been practiced in history that the force or the force should be submitted on that person, and
Counsel, I understand that there was a lot drawn in the ship, but I'm asking that did the President Qazalbash give his consent?
definitely, Your Honors.
Where?
Para 6.
Para 6. And then the para 7 he refused.
Your Honors, as we previously submitted that, according to this custom of sortation, if a person gives his consent once and he takes parts,
This is a true and die situation. Once a person has
definitely. This is what we are arguing. This is what we are submitting. If a person submits once, that according to this custom, he had to accept his fate. He had to accept his fate, and he cannot withdraw himself.
But there is no clearly written in the text that there was some sort of salvation or
It is written. Sortation is another term used for the drawing of lots.
Also, your time is up.
It seems that my time is over, and I would not take more time of this court. If the court allows me, I will just say my prayer. So, Your Honors, we pray that this court should impose the charge of willful murder on the accused Armagan Andawa and his company, and the charge of Section 34 common intention on Ruzagil and Frizzotel. May it please the court. Thank you.
The resolution you may proceed for rebuttal, and you have only 1 minute.
Thank you, Your Honor. Your Honor, with the permission of competent court, I have only 4 questions with the respected counsel. If the respected court allows me, may I start? Thank you, Your Honor. The first answer of mine that regarding jurisdiction, that from the opponent side, they really refuse that there is no any jurisdiction from the side of Juristan. Your Honor, if a state who claims for independence, and he already has fulfilled all those ingredients of a state, he have the capability to make an organized state, and he demanded, then how is it possible that he is not having jurisdiction to adjudicate the case? Is there any specific territory was signed among the foreigners? No. If state is showing that yes, I am the competent authority as prescribed in the competent law of their jurisdiction, so means they have the jurisdiction to adjudicate the case. Number second, Your Honor, if you allow me, I will just answer of the respected counsel of question number 2. Your Honor, they said that the respected counsel said that you can kill any person on the basis of necessity. If we forget all laws, either that is defined in the constitutional law or either that is defined in any specific law which is prescribed in jurisdiction, where is the concept of humanity? Is there any concept to kill any person on behalf to secure their self or to secure all the team? No. There, until unless either issue, though he gives willingness, but the religion of Islam, Juristan, and the concept of humanity cannot allows you to kill the person for the basis to secure the all team members. Third question, I answered to the respected counsel that they argued, they said before the competent court there was no common intention. Your Honor, they were all on one platform. They suggested each other, and the person who is trying or who make preparation is in mind, it will be attempt of murder, it will be attempt of offense, and they already shown the same that mingeria, adressia, all the ingredients of an offense. May I complete, Your Honor? Thank you, Your Honor. As complete.
Time is up.
Thank you so much. Thank you, Your Honor.
The defense counsel, you may proceed for rebuttal within 1 minute.
First, our opposition counsel did not mention which local laws say that you can prosecute a foreigner prisoner, and the state does not have any laws to prosecute foreign criminals in the exclusive economic zone. Besides that, they mentioned Islamic religion, while Armagan Randawa was a believer of Shanshu religion. And when they killed Gildrozin Kazalbash, Aruzagil had was not aware of it. Thus, they had no common intention. Thank you.
Please all rise. The court has adjourned for 5 minutes.